Edward Chen of the Department of Social Work at the University of Hong Kong to deliver his presentation. Professor Chen is an associate professor, and he's also a Fulbright scholar who received the Senior Research Award from the RGC Fulbright Hong Kong Research Scholar Program in 2013 to 14. He was also recently awarded the Hong Kong U Social Sciences Outstanding Research Output Awards in 2014. His research includes epidemiology and culture-specific risk factors for family violence, child and family polyvictimization, and he's the author of over 100 articles in various peer-reviewed journals and books, and has been very active in research in the region, predominantly mainland China, but as I understand it, he's expanding broadly into other parts of Asia. And we're very, very pleased to have him today to share his research on formal and informal social control, responding to family polyvictimization. Thank you, Edward.
Okay. Thank you. Good morning. I hope you're not that tired and still paying attention. So thank you very much for having me here. It's my honor to share with you some of my research and observations. And basically, the message is very simple, and somehow I feel like it could be a common sense to practitioners, but unfortunately, researchers or scholars are always falling behind and then get evidence to prove something that we might have already known about this. So my message is very simple, that we do see quite a lot of families. They are not just having one problem, not just having one type of violence in the family. So always they come together with multiple types of violence. So, but this simple message, I have already taken over 10 years to get evidence and then to show how complicated it could be. So, when comparing to the existing study, if we identify, for example, there may have over 10,000 or if not 100,000 of studies focusing on different types of abuse, we do see only probably around 100 to 200 studies studying the co-occurrence of partner violence and child abuse. That's the problem of the research in the field. Just like actually, David Finkel is a scholar, professor from the United States, and then we work together on some research project. He and his team identified the problem of existing approach of studying family violence. Basically, it's talking about it's a very pragmatic approach. Most of the study, they focus on a single type of study. And his team has already developed a measure on the child polyvictimization. They focus on child victimization, but look into multiple types of victimization. So from the study, basically they identify that about 1/5 of the children, they suffer from more than 4 types of violence. So that could be including the abuse in the family by their parents, peer violence or bullying in school, or community violence, etc. And for those party victims, they are highly related to the trauma symptoms. So as you can imagine. So basically, I followed the lead of this direction of research, and then add somewhat different types of violence in the family. For example, in the existing research, we find out that IPV could be related to elder abuse. This is the percentage, but the range is too wide because basically among these few studies, they are using different measures, different samples. And child abuse could be related to elder abuse, or we have a bit more studies related to child abuse and IPV. So, but then the problem is that the families, they are not they're not having the choice to pick up one type of violence. Somehow, because they have different problems, they may have experience for more than several types. So I look into, say, 3 types of more, and then find out that basically we don't have any study. focusing on that. So I have one publication this year focusing on family product victimization, not just on the child, but then to see if a family, they suffer from more than 2 types or even 3 types of violence, what happened to this kind of family? So these are the part of the figures. I collected data from Hong Kong and 5 provinces in mainland China. Basically, over half of them, they have suffered at least 1 type of violence. And if talking about 2 types of more, we have about 11%, and 3 types of more, we have about 2.5% of them, they suffer from more than 3 types of violence. That's including child abuse, IPV among parents, and also elder abuse. And from this analysis, we see that for, say, multiple types of violence that could be related to gambling, smoking, alcoholic, and substance dependence. So the more types they have been experiencing, the more likely that they have been associating with all this addictive behavior. And in terms of the consequence, we also find a pattern that for families or members, they have suffered for more than 2 types or 3 types of violence, they are more likely to suffer from PTSD, depression, and some other health-related issues like physical health, and especially for mental health issues. So I would say that this should be well recognized by practitioners. That so you see, for a person, they suffer more types of traumatic experience that could be quite suffering. But then the point is that we are not really looking into these issues from research and also from the system perspective. So I have another paper working on child victimization, and then I try to explain that, say, how come a family that could be suffering for more. So one approach is to look into the association between different types of abuse. And again, from this, we can always look into the very complicated statistics, but the message is also very simple, that if we see that if a family, they suffer from IPV or parental child abuse, in-law conflict, or elder abuse, any type of this, that could be increasing the chance of having a child being poly-victimized. So that means when we see one type of violence, it's very likely that they may be experiencing another type of violence in their family. So this message has already been proven from David Finkelhaus's study when they are working on the child poly-victimization in the United States. And again, this is only talking about the same message. So when you see the child poly-victimization, 4 types of more, then you see that it's very highly associated with parental IPV, parental child abuse, in-law conflict, and elder abuse. This is another figure, so using the odds ratio to show that the relationship. So unless you're very interested in the statistics, otherwise we just get a take-home message. So the conclusion is that we see that there are high preference rate of co-occurrence between different types of family and also family violence and also child victimization. And if we are focusing on the child first, if a child experiences one type of victimization, it's very likely that they will be exposing to another type of violence. For example, if a child being neglected in a family, you can imagine that the parents are not available to support the children, probably because of partner violence or other issues, family issues. But then you can imagine if that child has experienced bullying in school, basically, do you think that the parent will be available to help the child, to support the child, or advise the child to deal with the bullying in school? We are not saying that violence in the family is really leading or making it happen that bullying would be, say, occurred in the school setting, but it's always associated, probably because of the family functioning is not that good, and sometimes they may be sharing some other, we call it risk factors like gambling issues or addictive behavior. Some could be related to poverty. So this is another area that we are looking into. And some could be related to the family member suffering from chronic illness. Then the whole family could be quite stressful. So we haven't yet have a lot of data on this, but we keep working on this to identify the family-related risk factor. But anyway, we see that when a child or the family member, they suffer from poly-victimization, then we see that we can identify the very negative health and mental health impact on the family member, on victims, and also on other surviving members. Then we look into two areas of, say, intervention. One is from the formal service. The other is from informal service. That part is probably related to some figures that Buja has just presented. So for formal service, basically, although I said that the message should be very simple and direct, but the point is that when our services are highly specialized, especially in the United States, I share these figures among the scholars and also the practitioners. Although they find the message is very helpful, but they find it very difficult to break through the boundaries because, for example, they have CPS, Child Protective Services. If they want to make a referral, if they identify one of the parents or maybe the mother of the abused child is also the victim of partner violence, then supposedly if they are well aware of these issues, they should make a referral to another service like Refugees for Better Women or some other services. But the boundary is so difficult or so time-consuming for them to break through or even make a referral. Not to mention that it's not that easy for them to sit together and then discuss the issues. I visited Michigan for a year a few years ago, and then I can only recognize that within a small county, they can bring together some practitioners from different services and then make it a platform, like say for communication only. So it doesn't really imply that throughout the system, the whole system can work together to deal with the cases. So basically, when the services are highly developed and very specialized, that also implies that the boundary between the services are so at least not available to deal with the complexity of the family violence. So for family, if they suffer from different types of violence, that may be related to several types of services. And then it comes to our problem that whether we have, say, effort being made to break through the boundaries. This is what we have to consider. And also, supposedly, it should be very straightforward that if we see the association between different types of services, then supposedly, for a social worker, for example, in a shelter, if they are helping the abused women, but they also will be able to identify that a child could be also the victim of a child abuse. But then if we are more aware or well-trained to do the proactive screening for other types of abuse, that means you have to move a step further. That you're not just focusing on the services that you're ready to provide, but also take a step further to do at least a proactive screening for other types of abuse. That will be affecting your whole intervention plan. If you rely on the parents to prevent child abuse or to help children, but if they are also the victims of partner violence, basically you cannot take it for granted that they are available to help. They want, but they are not capable to help. Then you probably need to reconsider the whole intervention plan. And other issues like, say, not just involving social workers, but also probably in legal or criminal justice practitioners, that if they deal with the issues, that whether they can, say, take a whole look. I'm not talking about taking a whole family approach, and then maintaining the family harmony is the ultimate concern. I basically challenge this idea. So especially when we put together all these issues, especially in Chinese and also in Asian families, that it's not difficult to claim that we put the child, the benefit for the best interest of the child. Okay, but when the interest of a child and also the interest of adults or the family, they are in conflict, very likely that the children's benefit will be ignored. So it's like, I would say these are the competing values, that whether we really focus on child or women victims' welfare rights, or we sometimes consider so-called the whole family, the benefit. So I want to highlight one point that so in 2008, we have the amendment on DVO, Domestic Violence Ordinance. Now they changed the name to include the same-sex couples. So that was groundbreaking in the sense that they include the next friend. Before that amendment, if we want to apply for restraining order for a child being abused, they have to be represented by their parents. And that could be ridiculous because one of the parents could be abuser, right? And the other non-abusive parents, they probably will be the victim of violence, or they're not very, willing to apply for restraining order to stop the husband abusing the child. That could be quite complicated. But then with many parties' effort that we introduced the next friend concept. So basically, for relatives or grandparents or even teachers or social workers, supposedly if you are related to that child, you can represent the child to apply for restraining order. Okay, of course, eventually it's up to the judge to determine whether they will issue the order. But that could be groundbreaking because we are no longer assuming that parents are the only party represent the child. Because when they are not functioning well or even they are abusive, then probably the whole system should recognize that some other stakeholders relevant to the child should be available to help. In the past, they want to help, but they have no room to play their role. But right now, in principle, they have the right to do so. But then in reality, how many cases that could be, say, a private adult? So probably, at least I asked a shelter that they have been working on these issues. Probably, even for women victims, I guess probably for a shelter, no more than 10 cases in a year that will be, say, using this ordinance to help the victims, women victims or child victims. So if every year, right now in Hong Kong, we have about 4,000. That number is more when compared to Scotland, right? But it's still uprising. So that's pretty bad news that basically it doesn't really matter whether our economy is going good or bad. The reported cases have been increasing throughout the years. So right now, in last year, we have about 3,900 something, about 4,000 women victims reported to the system, and about approaching 900 child abuse cases. So even we focus on this less than 5,000 children and women victims, I wonder whether we have more than 100 cases applying for injunction order every year. So on paper, they have the right to apply for legal aid, but we keep learning that for legal aid service, they prefer to help them to proceed for divorce rather than applying for injunction order. So that could be related to the attitude of the practitioner, and also, so in Hong Kong, the issue is that it seems like we have the services available, including legal aid, but they are not accessible to different extent. So Buja has already mentioned some issues related to ethnic minorities or immigrants, but there are some other issues that could be related to even local residents. They also find it difficult to really access to the services they are supposed that they should have the right to access. So we should focus on this and then take a look. I highlight another issue. I keep using this example, and unfortunately, I don't see the situation has been improved a lot. That was a child being killed by the parents, not directly, but being locked in the suitcase, and then after a few hours, being killed. So it was about 10 years ago. But then the judge, this is a sentence, and then it's talking about that it has no public interest. That's funny. It has no public interest. So violence in the family, if you consider this is a private issue, yes, this is of no public interest. But if we have this mentality, then we have to reconsider the whole issues, whether family violence is really a personal or private issues. Of course not. Otherwise, we are not here to deal with the issues. Another point is that they assume that the parents, they have already lost the child, and then they suffer. Okay, so but it was these two parents, they put the child being locked in the suitcase, and that's not I don't believe that it's a common way of doing this, physical punishment or corporal punishment. But many parents, they do their own stupid way of corporal punishment in different ways. And it seems that the people are very sympathetic to the parents because they have already lost a child. But how to make a balance that they have just killed the child? And they are good people with father having a positively good character. That's we are familiar with all this defense, right? And then eventually they put the mother for a longer period of imprisonment. The mother was being put in prison for 2 years, and the father 1 year and 9 months. The reason why the mother should bear more, at least 3 months more imprisonment to bear the more responsibility, because that mother was present when the child was being locked. The father was also participating, but then they left home for the whole afternoon. Then I would say that very funny, it's really gender insensitive, because it's always the mother feel like you take responsibility for caring family, right? But then eventually it's the mother bearing more legal responsibility. And then what's the message? So I should be great, right, as a father, that if I ignore my family, then I would bear the little risk of any accidents or incidents in the family, right? That's not fair to most mothers. And also, they assume that they have another surviving child, that they just hope that, so with one of the parents being released earlier, then it would be helpful to take care of another surviving child. And I can never take it for granted that these parents could be protective anymore. Yes, they learn a lesson, but who guarantee that they can prevent another tragedies from happening? I have no confidence about that. So basically, how we have to consider all this, and is it the cost concern? Of course, they will argue that it's out of the business, it's not their business, but then it leaves social workers or other personnel to do so. But do we expect the judge to be more sensitive? In Hong Kong, I don't know, I don't want to bring the system, but basically we are proud of having a very independent legal system in here. But I feel like, say, when I visit, Rochester, I can go, I was invited by the judge to talk to them in the courtroom. When I was visiting London, and then I was invited to go there and then talk to the judge in the courtroom. But in Hong Kong, basically it's very hierarchical and it's very difficult to talk to the judge, and not to mention that they will be ready to learn from other people, like a psychologist or social worker or whatever. So basically, yes, they are very independent, but to some extent that they kind of, out of touch with the reality. And should we expect something like I say they should be, not just the judge, but the whole criminal justice practitioner, should they be more gender sensitive or being more concerned about the child's safety? I quickly highlight another issue that is about informal social control. Just like Butcher mentioned that quite a lot of, say, help-seeking behavior, especially in Hong Kong, and I believe in Asian countries, they turn to their family and their friends first. So when you compare this, of course, you can advocate for more formal services, which I agree. But we also need to consider that the informal support network are always available, but they can be protective and also be risky. It depends. Because imagine that if a victim, women victim, they turn to their family member or religious group, and then they show support and very sympathetic to the experience, and then they tell the women victim, go home and forgive your abuser. And then we are always support, but we don't want your family being broken down. Does it helpful? Is it really helpful? I feel like this kind of informal social support could be quite dangerous. But what I mentioned is that this the recent study that we focus on informal social control. This is what we can do for social workers and in your public education. We advocate among the informal network to be playing a role for social control. That means they are also upholding the zero tolerance of violence. They send the message very clear to the victim and also to the abuser. If the abuser is also the member of the community, then they should make the message very clear to the abuser, and then tell the abuser that we are going to intervene. And we are not assuming that this is only a private issue. So then it would be helpful. So if we are ready to send a message. So this is an article that we have been working. So we hope that although informal social control actually is somehow different from the formal services, but they could be part of our work, part of our intervention, that we can advocate the informal social control through the informal social network. So this is the message that I want to share. Thank you very much.
Thank you very much, Dr. Chan. I'm going to take liberty as chair perhaps to jump in and offer a few comments that relate to Dr. Chan's presentation before opening up for questions. Just to fill in sort of the numbers gap in terms of how many people are applying for civil restraint orders in the Hong Kong context. And I found from the sample I looked at, in the UK, it was about a quarter of the women were willing to apply for a civil restraint order. But because, as you said, there was reluctance to do so, the majority of them, so 60% were either separated or divorced from their partners. In Hong Kong, comparatively, only 4% of the women were going for that option among the ethnic minority and immigrant population, which I think is lower than the local Chinese women, but still quite close. So again, it's not a popular option for a number of reasons, including that it's very, very expensive, and then to apply for renewal of the injunction is also expensive. And in terms of separation and divorce, the rate was 20% among the ethnic minority immigrant group. In terms of legal aid access, as I said earlier, because there was a poor level of knowledge of the entitlement of ethnic minority and immigrant women about their access to resources, in fact, many of them were told they are not entitled to legal aid. But as we all know, immigrants and even non-residents are entitled to apply for legal aid if they have a proper claim that they can make, which would be subject to the discretion of the Director of Legal Aid. For those who did go through the proceedings, they found that divorce and custody proceedings were particularly challenging because it took up to 10 years. So if they have a precarious immigration status, they cannot work. Many of them anyway, they don't have the qualifications to get employed, and then they have no access to resources. Means they cannot afford to wait for that amount of time anyway. So the system is not considering their whole situation. It's just got a partial view of people trying to navigate the legal system. And of course, who is advising them? I found, going to the point you're making about judges, I found even counsel very ill-equipped and ill-informed about the situation of the women concerned, and they don't necessarily give them the best advice. So one of the victims I was speaking with told me that her lawyers told her, do not raise the domestic violence argument in the course of your custody hearing, because the judge will see you as a non-cooperative parent and actually will find against you. And she changed lawyers 3 times. So the last time she was persuaded to keep quiet, but then in the end, the lawyer changed his mind and said, well, why don't you advance the argument? And she did. And the judge then said, you are an unreliable witness. I can't trust you. Because if you've had domestic violence experience over the last 10 years, why do you just raise it now at the last minute, which was the last hearing relating to child custody? So you can see the ways in which, of course, for her is proof fatal because the judge has ruled against her. But the lawyers would say, well, this was my strategic move because I thought it would work in your favor. But it's coming out of a lack of experience and sensitivity to the specific situation. Judges, I remember having a conversation with a judge about a joint parental responsibility model of parenting, and I just asked her, well, what do you think about the role of culture in terms of trying to maintain family unity? Do you take that into account when you are exercising your judgment? And the judge's response was, what's culture got to do with anything? I just follow the law, right? Culture is irrelevant. And I said, well, but I'm sure that the client, the applicants coming before you have certain desires and preferences and how they will be able to live on with your judgment. And the judge says, nope, my role is just to apply the law as it is. That's what fairness entails. So it was really quite shocking. And then lastly, drawing on community network, I didn't get a chance to share the slides, but basically there are increasingly instances in Hong Kong where service providers draw on the informal community network, particularly in asking friends to come and be interpreters, or sometimes sisters-in-law of the victim, who are the sisters of the husbands, right, to come and be interpreters. And of course, that's the problem, and it exposes them to a tremendous amount of danger. But at the same time, informal social networks have been very useful in the UK and Australia when done properly. So, for example, a Catholic church has been found to be very supportive of a woman. She didn't tell them that she had applied for a divorce because she knew that may not be taken very well, but they helped her work through her violent sort of conflict situation and sort of find employment and access retraining facilities. For Australia in a Gurdwara, they didn't blame the woman, which is what has happened in Hong Kong, but instead provided childcare facilities while she found employment somewhere else. So I think with education and building good ties and alerting them to the dangers of perpetrator tendencies, these social networks can actually be useful. But as Edward said, I think one has to be very careful because you could potentially lapse into creating a high-risk situation. Polly?
Thank you very much. That was fascinating. I would say actually the reverse, that the judge in the case that Jack said.
Oh, they can't hear you. Sorry.
I would say that the reverse is the case in terms of judges mobilising cultural knowledge, that in the instance that Dr. Chan presented of the parents who'd locked the child in the suitcase, he was doing exactly that. And I was wondering whether, in the UK, child welfare law has really successively led from scandals, from the 1945 Child Care Act followed a scandal of a child death in foster care, and whether or not there was a wider cultural response in the newspapers and in the media to the death of that child. I was just interested what kind of repercussions there would have been in that recent case that you presented.
So it's some could be explicit, but some could be quite subtle. So if talking about so you mean the case I presented. So basically, my impression, but it could be subjective. But my impression was that it was not very blaming against for example, both parents, because they consider this case was an accident. And accident, that means, yes, I also trust that the parents, they are not intending to kill. But it doesn't mean that they are not intending to hurt, because they were intending to punish, say, using being locked in the case and then punish the child. So basically, I would consider that, of course, we never heard that, say, parents use this as a means of punishment. But as I said, many different parents, they are using many different stupid way of punishment. Then we cannot afford that, say, you keep trying out and then learn from this lesson and then to stop that.
So it wasn't framed as child cruelty or child harm?
I don't think that it is, because basically they consider most of the, not all, but most of the this discourse is basically considering this as an accident. And so as an accident, a child being killed, and then assuming that the parents will be very sad and very hurt, and so they have already received their own punishment in this way. So basically it's reflecting the cultural issues that we are not, if we, for example, I take a very strong way that I consider that at least the survival rights of the child, then I would consider, yes, the parents, they're murderer. And then, of course, I'm not advocating that you should kill the parents and whatever, but then we have to be very cautious about that. There's another surviving child, and we have to take very caution that to protect another child. And we have to send a very strong message to the public that we need to stop this kind of behavior. And it could be not many other, say, parents will be doing the same thing, but many other parents, they are justified to do their own way of, say, punishing their child. The same logic applies to even partner violence. Say, you know that for abusers, they always have their good excuse to use violence, and then as a means to discipline their evil wives. Then the point is that if we believe that even I am evil, you have no right to hit me, if we uphold this standard, then basically we don't need to consider any excuse or reason, right? So, but we have a lot of room to discuss whether these women should be punished or what. So then I would say that in our culture, we allow this kind of debate. And even in the criminal justice system, we always find this, say, implicitly. For example, we have practitioners, say, convincing the women victim to use other ways to do it, rather than using the way that the law has already promised to protect. And sometimes, but I just want to add up one more point that even for ordinance, it's not neutral. Because as the example I included, that when we introduce the next friend concept, that other people can be representing the child, we are using the law to break the culture. Because in our traditional culture, we believe that the parents, they have the full property right to own the child. But right now, we can change the law to change that culture. So I don't believe that the law are basically neutral. And if a judge saying that I only focus on ordinance, I would consider you finding out some excuses to avoid the job that you're supposed to do. So yeah, I add some more points about this. I have no good answer for this, but these are all the reflections that I have.
Yeah, my point was just to say that there should be framing of culture, not that culture should be a defense, but it should be part of the discourse rather than distanced, from it. Is it on? The red light?
Didn't work.
There we go.
I had pressed the button. I just wanted to check in terms of the numbers. In terms of recorded domestic abuse incidents in Hong Kong, I thought I heard you say something around the 4,000 mark, but could you just check for me if that's correct in terms of statistics?
For 4,000, they are reported cases.
Per year?
And I have compared that these 4,000 cases is about representing about 1 to 2% of, if comparing to my survey. From my survey, from my household survey, I reach out to the population and identify those hidden cases. And then only, if then compared to the 3,000 to 4,000 something, it's only representing 2%. Among all those, say, violence cases, they did happen within 1 year, but only about 1 to 2% of them being known to the system. So 4,000 is not a big figure comparing to US or in UK or whatever, but if you are comparing to the 7 million people and also comparing to, say, we are talking about approaching 100,000 hidden cases. Basically, we have only a few cases being known to the system. So these are
that's cases of domestic abuse known to the system.
Yeah. But there's also the issue I mentioned to you the other day, which is that the police has its own definition of what's classified as domestic violence, and then there are things that they're calling domestic incidents, and that recording of data.
Yeah, so that's recorded data, but that's like 10%. Yeah.
If among, say, among this about 4,000 women victim cases, I think will be, at least conservative speaking, less than 50% of them will be known to the criminal justice system. And then probably less than 10% will be eventually go through the court procedure and then being sentenced to for guilty.
Yeah. We have, I think, successful prosecution of 6%. Anyway,
well,
thank you very much.
I think that's on par.
Yeah.
Yes.
You
I'm
still
not
need
sure.
to press
Is the red
button.
button on?
Okay.
Perfect. Yeah.
Yes, I'm Odilai, barrister at law.
Hi.
In defense for barristers, you mentioned things that has a lot of, I will not say I'm guilty of it, but it's my job. When somebody comes to me and they will tell me they suffer some domestic violence, and I will tell them, I'm not here to listen of your heartaches. It's not my job. You go to your counseling, you go to church, you go to social service, but if you come to me, you only tell me what is that violence, and I'll go to court and fight for you. All right? And if I think we need to involve the police, we will involve the police. It's going to be a criminal offense. And you will be bringing your whole family into the courtroom, drag all the children, even necessary, in order to prosecute whoever that has to be prosecuted, because once you involve the police, it's criminal. That is the thinking of the police. Because the police does not have the power to be psychologists either. They also have their own jobs. All right? Just as well as the judge, who will only make a decision based on precedents, based on law. And if he makes decision based on culture, based on pity and all that, it will be appealed. All right? So what you are asking from us is not part of our job. So that is in defense. Why we do things the way we do. We are not surgeons that we can operate on you. We are not licensed to do that. We will only license to look at the legalities and look at the current law and fight for you based on those laws if there are some available defenses for you. Now, if you want to do this domestic violence things, this is civil family law. It's not criminal. All right? So if you do not have the finances, you go to legal aid. There's only so much budget also for legal aid for this type of cases. And number one, police and the court, main job is not to referee family issues, which is quite complicated. and we are not supposed to do those things. So I suggest that you have to find another area, another group of people, or probably another, if our social department here in Hong Kong, social service is not sufficient, then there has to be other departments probably that they will have to set up. But to involve traditional police work into family matters that will not amount to a criminal offense, probably a bit difficult, if you ask me.
I'm assuming that's directed at the incident I shared. It's not at all saying that lawyers should be doing anything other than what they're trained to do. Yeah. What's being said is that when you're developing case strategy and you're advising your client to omit referencing certain facts in your statement, with the view that the judge may look at your situation more or less favorably, what I'm trying to say is that there are conflicts. Right? There's a conflict between what the woman can convey about what happened to her and how that will affect her chances of the right she wants to have enforced through the court. Right? So this was a child custody case. And my point simply was that sometimes, because barristers are not well versed with the broader picture or the broader situation of victims, they may give advice that may end up hurting the interests of the client in another respect, and not even being able to achieve her primary objective, which may be to secure the child's custody. So,
that is in hindsight, but you are not the counsel. You are not privy to all the information that was given to you.
I appreciate
and as you already mentioned, there are already few counsels dealing with this case. So even I'm a counsel, I will never judge the advice of another counsel. It's unprofessional. Because at that point of time, there could have been different information that was given to the counsel, and it was best at that point of time. Either that, then they just have to go and appeal it.
Sure.
Could I? Yes. Sorry, I just wanted to make a couple of comments, because I think there has been many, many years of development and discussion across different countries and cultures about where the law sits in terms of this public or private issue. And one of the big differences in the UK for the Metropolitan Police, for the courts, was about 10 years ago. They identified that low-level domestic abuse incidents, which in the past they'd have called domestic and not dealt with, were actually often precursors to homicides. And that the homicides that they could prevent, that they could identify, were the domestic ones. And that because of that, the whole legal system stopped discussing the things like the barriers, the reasons for people not reporting, the cultural issues, the lack of credibility of the witness, where they changed their story and it's like, yeah, you don't sound good in court. They started to understand it in the context of ongoing abuse. So they started to make reference to people like myself. They started to do training for the police, the courts, the judges, about the experience of domestic abuse and about culture and about risks and about how a seemingly unimportant incident in the context of an abusive relationship, so not one-off incidents, but the whole package, disempowered people, made them confused, odd, bad witnesses. And it may be that it looked to the police like they were low level, but actually the police changed their views and said, oh no, every incident we go to, which is a domestic incident, which has nothing happen maybe, is a possible prevented domestic homicide. And that change, particularly driven by the Metropolitan Police, has hugely changed practice in public, private law, in how people respond, and how the judges, the top judges and the High Court judges in the UK take it very seriously. And I think the point that Edward made, which was about law is not neutral. The law is not neutral. Our laws, all of our laws, were set up years ago to protect the interests of male, middle-class men. And I think that without challenging your role as a lawyer, is in fact, it has to take part of that into it. It's not neutral, and we're changing the law. So anyway, I just enjoy you to change.
So in that case, you have to go to the legislative.
But you can
really
be the change.
Because how can I...
You can be the change.
How can you expect me to give you non-legal advice?
It's not non-legal advice. It's the fact that your legal advice has to be informed with the nuances of the difficulties, the cultures, the experiences and the realities, and that for all lawyers, for every person, it's all of our jobs.
I don't think so. If somebody comes to me and they tell me these things and I said, okay, what do you want to do? Shall we file for a divorce?
Yeah, but it has to be culturally...
What will I say? Shall I say, okay, let me listen to your problem. Probably you can be like this, more... I mean...
No. As a lawyer, we now would have the training for all lawyers, all professionals, all medics, all dentists, all vets are culturally trained and are trained about the impact of domestic abuse because it impacts on everybody. And I think that's what the only point I want to make.
And it has to be a global change. And then there has to be a basis for the judge to make those changes in their decisions.
So I'd just like to invite actually Liz to share with us the judicial training you mentioned and what has happened in England. So there is resistance, as Edward said, in Hong Kong's courts, from judges, from lawyers as well, because as you say, there's a very narrow vision of, well, this is a law and this is what we do. I think you can see changes already afoot globally and particularly in the UK where there has been judicial training on this front.
In Scotland, we have three levels of court, but 2 levels are run by lawyers. So we have a sheriff court, and the sheriff can sit to hear solemn or summary matters, sit with a jury as well, and we have a high court. And obviously the high court judges are seen as being highly influential, and they are the highest of the high. There's a very strong history of independence of the judiciary. So in the past, that meant that our lawyers said, no, we are trained, we have reached the epitome of our profession, we don't need training. And in fact, if you were to give us training, for example, around cultural matters, that would challenge the independence. About 5 years ago, the judges themselves decided that that wasn't good enough, and that for them to actually make defensible decisions that were fit for purpose and demonstrate that they were making good decisions, they actually needed training. So what they have done is they set up a judicial training committee, and they routinely train the judges in a variety of different matters. But for example, in terms of domestic abuse, they created a DVD of 4 key courtroom scenes. So from an initial consideration of bail to a pleading diet, to the trial diet and the sentencing diet, and, brought common issues about domestic abuse into, so they had actors play out the situation in court and issues about whether or not special measures and the presumption of innocence could be changed.
Yes, given all that, you are introducing uncertainty and inconsistency in the law, in the application of the law, if you bring in culture into it.
No.
So you mean once there's a Filipino violence, then there's be a different basis compared to an Indian, Pakistani violence, a domestic violence?
No, not at all.
I mean, how are you gonna...
Not at all, but this is the kind of
make
discussion...
this thing work?
This is the kind of discussion that the judges have, because what they do is they have a full day's training and they use the DVD with the examples, with information, with experts coming in, with psychologists, social work, etc., talking, and they have these discussions about, but that's unfair because I will make my decision on the basis of the facts of this case. And I think all the judges have decided that actually that's not good enough. But, I would be delighted, I don't know if this is possible, but to see if there's a possibility of sharing with lawyers first and judges second or whoever, that type of training, because I don't think it's for somebody like me to try and persuade the legal profession that there are ways to go. But I think some of your compatriots, some of the lawyers who are top lawyers, may well be able to explain why they have made a change.
Well, hopefully
just one point that many professions are redefining our job nature. So we scholars are no longer working in ivory tower. Even some medical doctors working in ER are ready. Of course, not 100% of the practitioners, but quite a lot of them, they are trained and ready to deal with violence issues. Although they are not psychologists, they are not counselors, but they are ready to ask some more questions and then to help identify abuse cases. And once they identify, they are not handling, of course, by themselves, but they refer to either police station or social workers. So what we need to do is that we go beyond our conventional boundaries and then to think say maybe a step forward to see whether we can connect with other professionals.
Holing.
Hi, my name is Holing. I just want to ask, I think where the change